the year 2015, it marked the 125th birth anniversary of Sri Babasaheb Ambedkar. Keeping in mind the 125th birth anniversary of Sri Ambedkar, a declaration was made by the Government of India that taking this auspicious occasion of 125 glorious years, that there should be celebrations all over India in respect of this founder of the Constitution. That is how the idea of celebration all over India came up, and also a foundation stone was laid in the memory of Sri B.R. Ambedkar at the Ambedkar Memorial. It was at this time that the Government of India made a declaration that 26th November will be called and honored as the Constitution Day in honor and memory of Sri B.R. Ambedkar. And from then on, we have been celebrating 26th November as the Constitution Day. The Goa High Court Bar Association has been organizing this lecture series every year on the occasion of Constitution Day. Keeping in with this tradition, this year too, the High Court Association is organizing this lecture series today to be delivered by none other than Senior Advocate Sri Rafiq Dada. I welcome you, sir, for today's evening, and I am sure we will all stand enlightened by the words that he has to share with the bar today.
All today to celebrate the 73rd anniversary of the Constitution of India, earlier celebrated as the Law Day. At the outset, let me tell you something about the Speaker of the Day, Senior Advocate Mr. Rafiq Dada. Mr. Dada, otherwise, as Mr. Agni says, needs no introduction, given that he is well known to all of us gathered here. My association with Mr. Dada has been as a student when he taught me income tax at the Government Law College, Mumbai, where I was a student of law. It continued thereafter when I started practice for some time in Mumbai and then in Goa, where I had then the occasion to work with Mr. Dada on many matters which were decided by the then Judicial Commissioner and subsequently the High Court. His profile as an advocate and as a designated senior advocate is unblemished.
Speaking after such a wonderful oration by Senior Advocate Mr. Dada would not only be a mistake but also a constitutional folly, and I am really not much prepared to make that folly, at least on the eve of this Constitution Day. So you please forgive me for what follows. That the Constitution is not just a lawyer's document, but it is a vehicle of life, and its spirit is the spirit of the age, very poignantly prophesied. He said, however good the Constitution may be, it is sure to turn out bad because those who are called upon to work it happen to be a bad lot. But however bad a Constitution may be, it may turn out to be good because those who are called upon to work it happen to be a good lot. These profound words, in my view, are a reminder, a siren call for all of us to strive and keep striving to become a good lot. The constitutions world over, however well drafted or crafted, do not work by themselves. They have to be worked by someone. But please do not be under the misimpression that the responsibility for working the Constitution is only of the three organs of the government, the legislature, executive and the judiciary. Such onerous responsibility equally lies on the people, we the people who gave unto ourselves this magnificent Constitution. Words on paper, no matter howsoever profound, are not sufficient to preserve a nation. Benjamin Franklin, as he was coming out of the Constitutional Convention in Philadelphia way back in 1787, was asked by a lady, "So what kind of a government have you formulated for all of us?" He replied, "Republic, madam, if you can keep it." The most important office in a democracy is the office of a citizen. In a constitutional democracy, the real and legitimate source of power is the people, we the people. The constitution is merely the people's will. Therefore, if there is a clash between the people's will and the law made by the delegate of the people, that is the legislature, then it is the people's will manifested in the constitution that prevails. This is the entire basis of the principle of judicial review of legislation. Therefore, every citizen must make the constitution work. In addition, every citizen must make the three organs of the government, as constituted by the constitution, work. For this, there must be sufficient focus not just on the fundamental rights, but also on our fundamental duties. In our constitution as originally enacted, there was no specific reference to fundamental duties, but this was perhaps because our founding fathers took it for granted that people would know that duties are implicit in rights and the two cannot but coexist. Rights cannot survive long without corresponding duties and responsibilities. But as time passed, the constitution had to be amended to remind us of our fundamental duties by an express reference in Article 48A. For a constitution to work or a democracy to work, citizens must, together with the discharge of fundamental, stand up for their hard-earned freedoms. They must not only respect the law, but they must strive to make the law more respectable. They must not only obey the law, but strive to enforce the rule of law by all constitutional means. The means are as important as the ends. Peaceful and creative struggles cannot be permitted to degenerate into violent or toxic fights. As a great nation of great diversity, we are bound to have great differences. These differences are not only natural, but they are inevitable. In a sense, they are pretty healthy for evolution of a democracy. Democracy does not require uniformity, which is usually available in a graveyard. On the contrary, dissent, though not for mere dissent's sake or for some narrow sectarian considerations, is welcome to a healthy democracy.
As you know, and I'm not saying it because some distinguished judges are with us, they were also part of the bar. There is a lot of stress and strain in the life of a lawyer who ultimately goes to the bench. And if there is some executive caprice which can affect his life in the matter of his appointment, in the matter of his confirmation, in the matter of his transfer, it leads to a serious problem. And therefore, in the Advocates of Association case, which was the earliest case, the Supreme Court said that no, the primacy in this matter will be given to the judiciary and the executive will not be able to do anything. In the matter of appointment, in the matter of transfer, recently we saw that in operation, it will be the collegium which will be deciding. So this, according to me, is a very important value. People say which country do you have, which place do you have a country where the judges appoint their own people? It's not like that. We have a special case here. We have a very difficult situation. We are an infant democracy. Maybe all our democratic elected members are not that educated, that well versed. So this requires a lot of supervision, and this is therefore a correct enunciation of the law. And this also, as you know, was challenged when the National Judicial Commission Act was passed. And under that act, the appointments were to be made by a panel of 6. 3 were learned judges of the Supreme Court, 2 were eminent persons who were not defined, and 1 was the Minister for Law. So this was also challenged before the Honorable Supreme Court. The Supreme Court struck it down and said that this is all very vague. What do you mean by eminent person? The Minister of Law is there, but he is also part of the executive. So therefore, the Honorable Supreme Court said that this amendment is also void because it is contrary to the basic structure of the Constitution. Now there are little hiccups in the life of this supremacy of the judiciary. One of the famous hiccups which I knew about was Naresh Kumar Mirajkar's case. As you know, in Bombay we have the original side where a single judge takes a trial and some of you presiding in Bombay also, see, they take a trial. A trial was going on before Justice V.M. Tarkunde, was a very distinguished judge. It was in the case of Thakkersi versus Blitz. There was a witness, I still remember his name was Bhaichan Gada. When he was giving evidence, he complained to the judge. He said, whenever I say anything in court, next day the papers reproduce in Gujarati, Marathi, English, and I am pilloried with the media. So Justice Tarkunde said that whatever this witness says shall not be published. Upon which some of the reporters pleaded, and they said that you hold the trial in camera. He said, I will not hold the trial in camera. I am passing a judicial order that it will not be published. This was done around 1:45 of that day. Those days the court sat at 2:30 or 2:45. At 2:45 a writ petition was moved by Mr. Naresh Kumar Mirajkar, who was a reporter of the Blitz magazine perhaps. And that was moved before two learned judges, the Chief Justice and one other learned judge. And the argument was that this judicial order affected the fundamental right under Article 19(1)(a) of the Constitution. And the question was, two, whether a judicial order could offend fundamental rights, and whether a High Court judge or two High Court judges could issue a writ against their brother judge, because they would have to set it aside by a writ of certiorari. The division bench refused to intervene, and they said, we can't do it. We are not going to issue a writ against Justice Tarkunde. Whoever is the judge, we are not going to issue it. The matter was carried to the Supreme Court, and it's a very famous reported case, Naresh Kumar Mirajkar versus the state of Maharashtra. It was a bench presided over by Chief Justice Gajendra Khatkar, and some of the important lawyers of the time appeared. And the fight was that what about freedom? What about freedom of the press? Because the press was powerful, maybe it's more powerful now, but they said, why? How can you stop us from publishing? Let the trial be held in camera. Ultimately, Chief Justice Gajendra Khatkar, who passed a majority, and there was a dissent by Justice Hidayatullah, who passed the majority judgment, said that a judicial order cannot offend fundamental rights, because the judges are the custodian of justice. If they do it in the interest of justice. Maybe an appeal lies against their judicial order or whatever, but you can't file a writ petition. You can't say that that order has offended somebody's fundamental right. So in a very brilliant dissertation, the learned Chief Justice Gajendra Khatkar upheld Justice Tarkunde's order, and then Naresh Kumar Mirajkar has now become settled law. Another very important event, which I'm sure you know, because many judges in Goa have had occasion to deal with it, the clash between the legislature and the courts. The most famous of those clash was when one Keshav Singh published a pamphlet in UP in which he made scurrilous allegations against some members of the UP Legislative Assembly. The Speaker of the Assembly happened to be a lawyer, and he said that this is clear contempt of the House. How can Keshav Singh say all this? So he said, bring him before us. And when he was brought, he was sent to custody and imprisonment for 7 days. You know the politics of UP better than I do. One day before he was released, a writ petition was filed that he should be released and his detention is illegal. That came before the Allahabad High Court. Notice was given to the respondents. The judges said, look, it's just 1 day, whatever. The respondent didn't come in the afternoon. Respondents were, of course, the assembly and everybody. So two judges, Justice Sehgal and Justice Beg, said, we'll release him, because this seems to be without authority of law. We don't know what sort of order is passed. Nothing is mentioned. Just a warrant for arrest and is put in jail. When the matter went to the Speaker, he was incensed and he instigated the entire assembly, and he said, let's pass a resolution calling these two judges, the advocate, and of course Keshav Singh, who had already suffered 6 days or 7 days, as contempt. Let them come before the House. The two judges heard it on a radio. Those were not days of TV or mobile phones or whatever it is. Because I know this story graphically. I had worked on this matter for my LLM. So they heard it on the radio. They telephoned the Chief Justice and said, tomorrow we are calling. So the Chief Justice early morning assembled every single judge of the UP court who are in Allahabad. They have two divisions, they have Lucknow's. They have 28 judges. They said they couldn't even find enough chairs, but all the judges sat on the rostrum and granted a stay against the order. When the matter went back to the assembly, again there was consternation because, a lawyer was presiding. And every lawyer does not necessarily know every law, as you know. So he said, no, how can this go? Suddenly the president decided to intervene and a reference was made to the Honorable Supreme Court. And as you know, this was one of the matters which Mr. Sirwai argued for the legislature and Niran Day and others argued for the courts. So the matter went on and finally a decision was arrived at, which is still debated every now and then. When a speaker's order is challenged, when something is challenged, it comes before the court is told by various esteemed colleagues that this is the law, that is the law. But the privileges of the legislature, which are there in Article 194(3) and Parliament, which are there in 105, remain to be undefined because they are the same privileges which the House of Commons enjoyed at the time when the Constitution was framed. So they have to be really legislated upon and laid down. But some jurists said that if you legislate on it, it will be tested as violative of some fundamental right. So legislation is dangerous. Now, among the various things which remain to be legislated, this is one of them. Of course, it's a matter of great satisfaction to many lawyers when there is a defection, when some chief minister goes, the speaker decides, speaker doesn't decide. And a lot of debate, as you know very well, has arisen from issues arising in Goa, and these debates will still go on. So this is one of the grey areas, but this is part of the issue of what is the judicial supremacy in matters like this. Judicial supremacy versus parliamentary privilege, judicial supremacy versus legislative privilege. These are the vexed questions which have to be debated and are being debated from time to time. Justice Gadendra Gatkar, I think he was also presiding in that. He said if there is an arrest by a general warrant, the court can go into it. But if it's a specific warrant, the court cannot go into the various grounds mentioned therein. Anyway, this still remains one of the ambiguities which remains, but to my mind, still is part of the value of the supremacy of the judiciary in the Indian Constitution. I don't want to end on an ambiguity. I still want to say that today we are celebrating a very important event. Most of us, all of you, have left your work and you have left your leisure, which is there on Friday, to celebrate this day. Why are we doing it? We want to revisit some of the values. A value which maybe the people who came before us, the great giants who came before us, laid down and left it to us. We are in a position in history where these values are now with us. We are the trustees and the custodians of that value. We have to preserve it, we have to enrich it. So today, I would respectfully submit, with great respect, let us celebrate the rule of law, the rule of democracy, the rule of freedom, and all the values which I have told you. This celebration surely can be enough justification for this gathering. I'm sure you don't want any further justification, and you will not accept any lesser justification. Let this day also be an important day in your album of memories. It will be in mine, because I love this bar just as much as I love my home bar. So the album of memories will preserve this day, 25th November 2022, the Indian Constitution Day. 1 embodies the principle that you shall not discriminate. 17 embodies that principle. And therefore, even if it's an Adivasi who's very poor, who may be having some reservation, but suppose he's poor and he's not able to avail of that, there is no reason why the EWS reservation should be denied to him. The majority, of course, did not agree with them. But this was one of the finest expositions of the doctrine of equality before the law, which is enshrined in the Constitution. The third value, which I believe is a cherished value, is the value of secularism. This has been added in the preamble to the Constitution by an amendment. In Keshav Nanda Bharti's case, Justice Khanna held that the state shall not discriminate against any citizen on the ground of religion. In Indira Gandhi's case, Indira Gandhi versus Raj Narayan, Justice Chandrachud explained the basic feature of secularism to mean that a state shall have no religion and all persons shall be equally entitled to freedom of conscience and freedom, the right of freedom to profess, practice and propagate religion. The secular character of the Constitution is a matter of conclusion to be drawn from articles confirming fundamental rights. Secularism is an inalienable segment of the basic structure of the country's political system. This was decided in the state of Karnataka versus Dr. Praveen Bhai Togadia. The learned judges have also come to the conclusion in one of the famous cases, Commissioner versus Acharya Jagdish Avaduta. Our constitution is neutral in the matter of religion and sympathetic to various religions, creeds, however unacceptable they may be in the eyes of the non-believer. Articles 25 and 26 embody tolerance for all religions. This is subject to the consideration of public order, health and morality. It is not open to anybody to question the tenets and practice of a religion, however irrational they may seem to be to an outsider. But a classic enunciation again came in the decision of the Honorable Supreme Court in TMA Pi Foundation, where, as you know, the right of a minority education institution which received aid to reserve seats for its own community came up for consideration. And 6 judges of the Honorable Supreme Court said that they could keep, but not beyond 50%. Balance 50% would have to be open to the members, the other members, other communities. 2 judges of the Supreme Court said that if they took aid, then they would not entitled to make any reservation. In the context of this, disagreeing with those 2 judges, Justice Ruma Pal gave a brilliant enunciation of the concept of secularism. And she looked into the whole matter, looking at the historical antecedent of this provision, which had come now into the Indian Constitution. Because there are very few secular constitutions in the world. Many of them follow one religion or the other. The whole of Middle East, for instance, follows only one religion. So there are very few. This is one of the few constitutions. So the learned judge, Justice Ruma Pal, was pleased to say that the earlier days, the whole issue was the church or the clergy was so powerful in Europe that they never allowed any interference with by any other religion except their own. But slowly that wall began to break because more and more people came from different faith, and the word secularism then came to be associated with those constitutions. And she said, in a more limited and distilled meaning, this is secularism. But she said that as far as the Indian Constitution is concerned, her language was, in a country like ours, with so many disruptive forces of regionalism, communalism, linguism, it's necessary to emphasize the value of secularism. And she said it means that this is not a theocratic state. Although it recognizes the importance of every religion, this is one of the few constitutions which allows every religion to practice, profess, and even propagate their own faith, so long as they don't offend public health, morality, and order, public order. So therefore, this was one of the important values in the Indian Constitution. One more value, of which very little has been spoken, is the question of fraternity. What is it? Is fraternity just friendship among friends? But in Indira Swani's case, the Supreme Court looked into it very closely. And they said that this represents the fraternity between different religious, communal, caste, languages, various people who come together. Many of them in the Indian cities today, nobody knows who is from where. Many are in the offices, nobody knows what's a man's surname or a woman's surname, only the first name is known. So the idea of fraternity is slowly growing, and this is one of the important values of the Constitution. As it was said in the famous case in Raghunath Rao, Ganpat Rao's case, that it is necessary to emphasize the unity and integrity of the country by this value which is there. This can be preserved by a sense of brotherhood. India has a common citizenship, and every citizen should feel that he is an Indian first, irrespective of any other basis which characterizes him: caste, community, language, religion, whatever it is. So, fraternity as a concept is the concept which helps people to unite. And very often people are not noticing it, but it's a very important concept. It works in real practice, as you can see, that people are slowly coming together. They come together in professions, they come together in various spheres of life. But this, in my view, is also a very important value. Then one important value, which I'm sure you're all very familiar with, was the value which was enunciated in the Keshavnanda Bharati's case, where the Supreme Court, by a majority, came to the conclusion that the basic structure of the Constitution could not be violated. There was no basic structure laid down anywhere. Some judges said that the basic structure is found in the preamble. Other judges said that no, basic structure is inherent. Let's not define it completely. Let's keep it open. That the basic structure of the Constitution became a sacrosanct principle under which every law could be tested. Even a constitutional law could be tested. The last of the tests was the 103rd Amendment, which was decided recently. The issue of basic structure, as you know, came in the Keshavnanda Bharati case, which by a majority of 7-6 was decided. Soon after that, the Prime Minister who had lost again won and decided to have a constitutional amendment. And Article 368 was sought to be amended. And the amendment was that all articles of the Constitution could be amended. There was no power or there was no detriment or any prejudice to anyone if any part of the Constitution could be amended. That was tested by somebody who owned a company in Bangalore called the Minerva Mills. And he had some right of property which he wanted to enforce. And he challenged this amendment because when he went to his lawyers, the lawyers were very distressed with this amendment. So they said, let's put this in your petition. And of course, this was one of those classic cases where the operation was very successful, but the patient failed. He died. How was it successful? In Minerva Mills' case, the most redoubtable advocate of his time, and perhaps one of the greatest we have had, Mr. Palkhiwala, decided to fight this amendment and said that this amendment, which said that basic structure now goes away, is totally violative. And he said, how is it violative? Among the arguments was that it is violative of the basic structure. And he had his usual flair and usual style, and by a majority of 4-1, the Minerva Mills succeeded, and that amendment was ultimately defeated. So basic structure came to stay, and it has continued to stay. In the last judgment, which was decided on the 103rd Amendment, the 103rd Amendment, EWS, was challenged on the ground of the principle of the right of equality. The majority said that this is not violation of the basic structure. And their words are very important. They said, we will not accept this as a violation unless the violation is shocking and unconscionable or an unscrupulous travesty of the quintessence of equal justice. Now, this is a point which constitutional scholars would have to look into, because does it mean that when it is violating the basic structure, the court can still say that unless it shocks my conscience, I am not going to set it aside? Anyway, this is a matter open for debate. It was decided very recently. 3 out of 5 judges took this view. So the question is this liberty we had even before the Constitution? He said Article 21 cannot be considered to be the sole repository of the right to life and personal liberty. Even in the absence of Article 21, the state has got no power to deprive a person of his life or liberty without authority of law. This is an essential postulate and basic assumption of the rule of law in every civilized society. According to the learned judge, the law in force even in India, before the coming into force of the Constitution, no one could be deprived of his life or personal liberty without authority of law. Such a law continued to be enforced by virtue of Article 372 of the Constitution. And as you know, the Criminal Procedure Code had a writ of habeas corpus. Article 226 had a writ of habeas corpus. So Justice Khanna said that right could not have been taken away even during the emergency. Justice Khanna also said that Article 226 has not been suspended. So if somebody moves the High Court, his right to relief cannot be affected. And therefore, he gave this judgment and he said Article 226, the High Court can always issue writs of habeas corpus. 4 of the learned judges, who were very distinguished judges of their time, disagreed with him, and the law remained where it was in ADM. Many years later, in 2017, in K.S. Puttaswamy's case, the whole law was given a fresh look. I say this with some affection because I used to appear before K.S. Puttaswamy when he was a judge of the Bangalore High Court. He was, I hope he's alive, I don't know, he was 98 when this case was argued in the Supreme Court when he was the petitioner. He was an outstanding judge, always prepared, and it required a tough lawyer to get the better of him if the judge had already made his mind. So this man fought back and he said no. The whole matter of H.R. Khanna's judgment has to be reconsidered. And it came before 9 judges of the Honorable Supreme Court. Justice Chandrachud wrote the main judgment, the present Chief Justice of India wrote the main judgment. And he said that the 4 judges in ADM Jabalpur were wrong, and what Justice H.R. Khanna said was right. What he said was that in K.S. Puttaswamy vs. Union of India, 2017, 10 SCC, page 1, the judgments rendered by all the 4 judges constituting the majority in ADM Jabalpur are seriously flawed. One of them was Chief Justice Chandrachud, who was the father of the present CJI. Life and personal liberty are inalienable to human existence. These rights are recognized in the Keshavanda Bharati case as the primordial rights. They constitute rights under natural law. The human element in the life of the individual is integrally founded on the sanctity of the dignity associated with freedom and liberty. I am not reading the whole quotation, but in his usual style, it's outstandingly written, beautifully written. And he also said that there are some flaws in this whole reasoning. He referred to some portions of the US Constitution in one of the paragraphs, and I just am tempted to read that. Before I part with the case, said the present CJI, that time as Justice Chandrachud, I may observe that consciousness of the view expressed by me, it is variance in the majority of my learned brothers, has not stood in the way of my expressing the same, and definitely the desirability of unanimity if possible. Unanimity obtained without sacrifice of conviction commends the decision with public confidence. And ultimately, the learned judge said that ADM Jabalpur is now overruled. And he also went on to say that all those judgments which followed ADM Jabalpur should also be overruled. Then, the present CJI also said that the histories of nations are written and critiqued. There are some judicial decisions which are at the forefront of liberty, but should never have been. The decision of the US Supreme Court in Buck vs. Welch ranks among the latter. It was a decision by Oliver Wendell Holmes, J., who accepted that possible sterilization by tubular ligation of carrybucks was a part of the program of state-sponsored eugenic sterilization. No lesser judge than Holmes accepted it. Holmes, while upholding the program, opined 3 generations of imbeciles are enough. So he said, if the ladies just producing imbeciles, let's accept the sterilization. Unfortunately. In the same vein, said Justice Chandrachud, was the decision of the US Supreme Court in Kevermatsu versus United States, which upheld the imprisonment of any citizen in a concentration camp because he was of a Japanese ancestry. And that happened to be the law even in the United States. So finally, the judgment in ADM Jabalpur was overruled and a new dimension was added as it was required to the law of personal liberty. I go further because there are some issues which are still requiring consideration, and I would refer to a final judgment which has been given recently, presided over by His Lordship Mr. Justice Ambedkar, who considered the constitutional validity of the Prevention of Money Laundering Act, and a judgment which was delivered a few weeks before he retired. The issue which was under challenge was the issue of onus of proof, which appeared to have been reversed, and a prima facie presumption of guilt instead of a presumption of innocence. The difficulty of getting a bail in such cases, and also a provisional attachment of a property without even a final determination. All this was upheld by the five-judge bench, and their lordships are pleased to observe that this is a draconian measure, but it is for a more draconian problem, that is money, and therefore we see no reason why this should not be upheld. However, a few days thereafter, there was a consternation because more than 200 petitions were decided, and various people asked for review. So the Chief Justice Ramana, as he then was, decided to review these issues, including the question of onus of proof, the difficulty of bail, and also provisional attachment. And you perhaps heard retired Chief Justice Lalit, who spoke on Monday of this week, the issue of the fact that in these cases, conviction is very poor, conviction rate is abysmally poor. So people are detained for a very long time. And he said thousands of bail applications are pending. In fact, on Monday I learned that more than 3,000 bail applications which were in the Supreme Court, coming from various courts, and the present Chief Justice was very upset with it. So on every single day, every single bench was asked to do at least 10 bail applications to get rid of the 3,000 which were pending. So this is the issue on personal liberty. This is where lawyers come in. You have to really look into it. You have to really make your own value judgment and see how best this issue can be pressed forward. I can't discuss too much about this because the matter is now in review. The second cherished value in the Indian Constitution, and I find my memory very easy because most of it is written there, is the doctrine of equality. Equality as an abstract doctrine is also a very cherished value in the Indian Constitution. Equality before the law and equal protection of the law. Many people were trying to figure out how these two words were placed. Then it was found that one was taken from the Irish Constitution, the other was taken from the American Constitution. But abstract equality was a dream of the philosophers. As Anatole France, the great philosopher, said, the law in its majestic equity says that both the rich and the poor cannot sleep on the pavements. So the law is equal, but it may operate unequally against some and not so equally against others. Ultimately, the Supreme Court did find a solution to this because abstract equality is just not possible. So the courts found the solution that equality was among equals. If equals were treated unequally, then it was a violation of the principle of equality. A new dimension was added to Article 14 in one of the cases in 1999, the MI Builders case. What happened was that a very historic park in Bangalore was handed over to a developer to make a Palika Bazaar. This was challenged by the citizenry of that city and went up to the Supreme Court. The Supreme Court said that equality has been violated. This is an arbitrary, unfair, unjust action is violative of public purpose, is violative of public interest, and therefore we should really strike it down. Another dimension, as you know, because I said I'm carrying coals to Newcastle, was added in Royapa's case, where they said that equality also requires every law to be just, fair, and reasonable. So a new test was laid down, and that added a new dimension to the principle of equality. This was, in my view, a very important development, because this required that even detention laws could be tested on that basis. Every single law which abridged anybody's freedom would also have to be tested on the ground that it was just, fair, and reasonable. Another important invocation of the doctrine of equality was in the judgment of Justice Nariman and Justice Lalit in the Sahara Banu's case, where the question of oral talaq was considered by the Honorable Supreme Court. In a bench, a decision of 3:2, it was held that oral talaq was invalid. Various judges had different touchstones to decide this issue, but Justice Nariman and Justice Lalit said it was violative of the Equal Protection Clause, which is taken from the US Constitution. As he said, Justice Nariman said, Article 14 is a facet of equality of status and opportunity spoken of in the preamble to the Constitution. The article naturally divides itself into two parts: equality before the law and equal protection of the law. Judgments of this court have referred to the fact that equality before law concept has been derived from the law in UK, and equal protection has been borrowed from the 14th Amendment to the Constitution of the United States. In a revealing judgment, Justice Subbarao, dissenting in State of UP versus Dioman Upadhyaya, said that whereas equality before law is a negative concept, equal protection has a positive content. So if it had a positive content, a judge could invoke it to strike down something like an oral talaq, which had certain things attached to it, and which may be required to be considered seriously in the courts. But to my mind, the most important development in the law of equality is now in the dissenting judgment of the Supreme Court in the case where the constitutional validity of the 103rd Amendment was challenged. And that was very recently decided, just 2 days before Chief Justice Lalit retired. Chief Justice Lalit and Justice Ravindra Bhatt were pleased to give a dissenting judgment. And they said that the 10% reservation for economically weaker sections of population was violative of the basic structure of the Constitution, because it was violative of the doctrine of equality. The learned judges said that this reservation of 10% excluded the scheduled tribes, scheduled castes, and OBC. My esteemed colleagues, all my other esteemed colleagues, because I also regard myself as part of this bar, members of the registry, members of the Legal Service Authority, ladies and gentlemen. Many years back, Rabindranath Tagore wrote a beautiful book. It was called Hungry Stones. And in that book he said that if the stones of a building were asked to tell their tale, they would tell you about what happened in that building. This building is a new building. It's a distinguished building, but it will also have a history of its own. Today is a historic day. I don't say it because everybody says it. It's a historic day because you're sitting on a Friday evening celebrating the advent of the Indian Constitution. When the President, Mr. Gilman Koyo Pereira, for whom I have a very fond regard, asked me to speak on the Constitution, I thought to myself that will I be carrying coals to Newcastle? What do I tell them which they don't know? So then I said, perhaps I'll make an attempt. I'm sure they know everything that I'm going to tell them. But it is necessary sometimes to revisit some of these values and have a fresh look at it on this occasion. As you know, the Indian Constitution, as was mentioned by the learned President, is one of the largest in the world, probably the largest in the world. It has suffered more than 100 amendments. The last amendment which was validated by the Supreme Court was the 103rd amendment, with Chief Justice Lalit and Justice Ravindra Bhatt gave a dissent and 3 judges upheld it. That was given only recently, just a day or two before he died. So it has suffered many amendments, but is still standing and is standing the test of time. What is it that is so beautiful about this Constitution? It represents the hard work of many people, many of whom were giants in their own time, who had given up everything to fight for freedom, to fight for independence. And some of them were outstanding lawyers, but never went to the bar to make the money which they deserved to make. They worked in the Constitutional Assembly. So it was a series of compromises, a series of drafts which were exchanged, a lot of points of view which were indicated, and finally the Constitution emerged. We have, as lawyers, used the Constitution because we have invoked it in many of the matters which will come before their lordships. Their lordships have been at the bar, they have also in the pyramid. This Constitution, as you know, has some cherished values. All of us know them. Should we revisit them? Let's do it today. What is the most cherished value in my view? The most cherished value was personal liberty. Personal liberty was the first which I think deserves the highest importance. Because the people who fought for independence, the people who fought for freedom, they fought for liberty. The fight for liberty has been the biggest fight in the history of human beings. It may be a fight against a monarch, it may be a fight against an oligarch, it may be a fight against a dictator, it may be a fight against a tyrant, but there has always been a fight to get liberty. What is this thing called liberty, which we all take it for granted, but only God forbid if it is abridged, then you really know what it is all about. The earliest case when the Supreme Court was called upon to decide this, as you know, was the A.K. Gopalan case. And the Supreme Court took a view, because it was very early in the life of the Supreme Court, that no person can be deprived of his life or liberty except according to procedure established by law. So the Honorable Judge said, so long as there is a valid legal authority, a person can be deprived of his liberty. So Mr. Gopalan failed to get any relief from the court. This sort of attitude went on, and the question of whether the law by which the liberty was abridged or affected could be tested by any other principle of constitutional law was not yet initiated. Unfortunately, during the emergency in 73 or thereafter, came the famous case, ADM Jabalpur, where 4 judges of the Honorable Supreme Court said that even if there was a proclamation of emergency and fundamental rights were suspended, the right to move the court was also suspended. No relief could be given to anyone. This was notwithstanding the fact that a man may say that it's a case of mistaken identity, or it may be a case of modified transfer, modified detention. The court said no. There is no reason, because it's procedure established by law. This is the emergency, there is nothing to be done. Only one judge had the courage to dissent. And among the historic dissents, as you very well know, you know his name, was Justice H.R. Khanna. He stood up and he was ready to be counted. He suffered a detriment. He was the next senior judge and he never got his chief justiceship. he resigned because he didn't vote. But that's neither here nor there.
आमी कॉन्स्टिट्यूशन डे हा जो फाल्यां ताका कित्याक लागून आमी सेलिब्रेट करता तो
26 नोव्हेंबर 1949 आमचो कॉन्स्टिट्यूशन फायनलायज जालो आनी तो एडॉप्ट केल्लो आनी 26 जानेवारी 1915 तो इफेक्टान आयलो. सो हो 26 नोव्हेंबर 1949 हो जो दीस आशिल्लो जेन्ना कॉन्स्टिट्यूशन एक्चुली आमचो जल्माक आयलो ताका आमी पयलीं सदांच लॉ डे म्हणून सेलिब्रेट करतात. 2015 आंबेडकर सरांची 125th बर्थ एनिवर्सरी आशिल्ली. तांचे 125th बर्थ एनिवर्सरीच्या निमतान आमच्या प्रायम मिनिस्टरान एक अनाउन्समेंट केलो की ताची 125th इयर शूड बी सेलिब्रेटेड इन अ व्हेरी बीग वे. आनी 125th इयराच्या निमतान तांचें एक मेमोरियलाचो फावंडेशन स्टोनूय ले केलो. त्या दिसा जेन्ना फावंडेशन स्टोन ले केलो तेन्ना प्रायम मिनिस्टरान डिक्लेअर केलें की हो 26 नोव्हेंबर त्या दिसाच्यान कॉन्स्टिट्यूशन डे किंवा संविधान दिवस म्हणून आतां ताका जाणून येता. सो तें आमी लक्षांत धरून दर वर्सा हो 26 नोव्हेंबर जो दीस आसा आमी ऑल ओवर इंडिया कॉन्स्टिट्यूशन डे म्हणून सेलिब्रेट करता. आनी फाल्यां हो दीस आसा आनी आज आमी तो दीस सेलिब्रेट करता. आनी एज गोवा हायकोर्ट बार एसोसिएशन वर्षा पद्दती प्रमाणे आमी दर वर्सा ह्या दिसा एक रिनाउंड स्पीकर हाडून कॉन्स्टिट्यूशन रिलेटेड सब्जेक्टाचेर आमी सदांच एक टॉक ऑर्गनायज करतात. सो आज आमी हो तोच टॉक ऑर्गनायज केल्लो आसा आनी एक सामकें जाणें आशिल्लें नांव जें आमच्या लिगल सर्कलान फेम नेम आसा सिनियर एडवोकेट रफीक दादा जे मुंबयचे आसा ते आज हांगा गोंया येवन हे कॉन्स्टिट्यूशन डीचेर तांचे जे कितें विचार आसा ते आज ह्या इव्हेंटान आमकां आज एक वरभराचें तांचें टॉक आसतलो. आनी ह्या फंक्शनाक आमचे हायकोर्टाचे जजीस प्रेजेंट आसा आमचे महेश सर आनी देशपांडे सर जे आमचे हांगा सिटींग जजीस आसा. तशेंच सिनियर एडवोकेट्स आनी ऑल ओवर गोवाचे जे लॉयर्स आसा ते सगळे आज हांगा एकठांय जाल्ले आसा हो दीस सेलिब्रेट.